Legally, with refusals, and it occurs a lot, there's a misconception where people think they have to take the breathalyzer test. Legally, the officer, the arresting officer, has to give you a choice whether or not to take the test. They're supposed to, by training and by police department protocols, read off a sheet or a card that gives you the DWI warnings, that advises you that you've been arrested for DWI. You're now going to be asked to submit to a chemical test, and chemical test evidence will be used against you, and whether or not you want to submit to that. They also advise you, if you refuse, that your license can be suspended through a refusal hearing, but they have to give you a choice. Many times they don't, that being said. And most people don't realize that they have a choice, that you can say, no, I don't want to submit to a test. If you don't, the criminal case against you is weaker because there's no chemical test evidence that can be used against you, your own blood work, your own breath, to show what the alcohol content would be. The police can still pursue the case based upon the common law charge of their belief that you're intoxicated, but they don't have the additional evidence of your own evidence against you from what's in your bloodstream on your breath, of what the alcohol content would be. So it is a much weaker case. DMV ultimately will treat you separately and can pursue you for the refusal, but that occurs after the criminal case is completed. So it's better in most instances if you don't submit to the test. Because unless you would know that you're completely sober and less than a .08 reading in your bloodstream, most people don't have a good understanding or would have the scientific background to know what their reading level would be. When in doubt, you should not submit to the test.